You're welcome back. This Newsfile is your most authoritative news analysis show. I'll introduce you my next set of guests to discuss the rest of the issues that we have put before you. And before I do that, some of the comments that came in. This one is coming from Professor Stephen Kweku in the United States of America. He says the purpose of the exhibition process is to allow the Commission to establish the qualification of persons whose registrations are challenged. NHIS card registrants have been disqualified by law. No further actions are needed to establish their disqualification. The court ordered the EC to remove these registrants immediately, but to allow them to register anew if they can establish via other legal mechanisms that they are qualified. This is not a matter of law. It's a matter of English comprehension. Okay. This one too from Kwabena in Ansubwa. He says, please tell Dr. Raymond Natuguba that whether Abu Ramadan lost or not, what matters and its material is that the Supreme Court has given clear orders to the EC to obey, failing which the commissioners would be in contempt. Yes, in jurisprudence, you can lose your case, but once the court gives clear orders which are grounded in law and enforceable afterwards, I will be happy insofar as those orders inure to my benefit, as is the case in the Abu Ramadan Nimakun versus the EC and Attorney General. Then James Ferron says, confusion. Which version of the law is Dr. Tuba applying, and what is the relevance of insisting that Abu Ramadan lost the case? Why are people creating so much confusion instead of helping the system to move forward? We've got a couple more of your comments that I will share as far as this matter is concerned. Now, well, for those of you who think that you needed another side of the story, I'm sorry to disappoint you. There's no side of the story that's not been heard. This is the side of the story that we here on Newsfile wanted to hear. And it doesn't even matter that I disagree with some of the sides. We need to hear the side. So thank you very much. And this one, okay, I've got to take this. Okay, now, one of the biggest blocks to people, both lawyers and non-lawyers, understanding and making progress in law is reducing every matter to a win or lose. That is the problem with people's confusion over the Supreme Court's decision in the Abu Ramadan No. 2 case. No one won anything and no one lost anything. And this is Ace Ankoma speaking. The plaintiff got some of what he asked for and didn't get others. Is that a win or lose or both? A win and a loss. Then the court itself made further consequential orders, which are what are in issue now. Note, the court would not have had the opportunity to make those orders of if Ramadan hadn't gone to court. That's what you wanted to say. If Ramadan hadn't gone to court. So is that a win or a lose or both? And so reducing those key orders of the court into win or lose is childish and uninformed. And that's what is creating the confusion in people's minds. And unfortunately, that includes some persons with legal training. Then Felix Dade says, fine partisan legal article is what Dr. Tuguba served us. Okay, that the interview has exposed some gaps. Well, okay. Kwabena Ejekum says, I'm very much confused too. Constitutionality and void versus accuracy and credibility, or policy versus substantial. You ended there. You say, Ohiniba Nanayako says, Dr. Raymond Atuguba, the respected lawyer, is confusing me and many others, possibly. Max Milan Quartin says, a clear case of majoring in the minors This explanation is confusing even legal minds. Okay, so those were some of your views that you have expressed as far as the discussions are concerned. Thank you very much. Now, this show, as always, is brought to you by MTN. Welcome to the new world. Star Assurance, creating smiles since 1985, celebrating 30 years of solid partnership. NIIT, bringing people and computers together successfully. Having mosquito coil. That's what you need to have a very peaceful sleep. Now, if it is the case that you're a public service worker, you're in the civil service, and you need a bank loan urgently, and you can't tell where it will come from or which bank will give you, I tell you, go to Bank of Africa. No libby. You just get there and they sign you on. Within 48 hours, you get your loan and you have 5 solid years to pay. In fact, you have 3 whole months to relax to determine how you go about paying. Bank of Africa is as strong as a group and close as a partner. They are all over the country. If your internet could speak to you, what would it say? Imagine waiting for 4 hours just to cook instant noodles. 4 hours to cook instant noodles, right? What if it had to take you long hours only to download a short video? It can be very disappointing and annoying, I tell you. So this is what you do. The wait is over. There's a better internet experience for you. Switch on to MTN 4G LTE and enjoy a whopping 100% bonus when you bundle. To get started, simply dial *585# to check if your device is 4G compatible, and then visit any MTN service center near you with a valid ID card. This one, you can take a NHIS card. It will not be rejected. And make your switch today. Enjoy better internet experience on Ghana's only 4G network on the go and say hello to the future. MTN, welcome to the world. And Star Assurance, as you know, that is where when you ensure the dangers are made to appear as if they simply don't exist. They exist in the dream world. They don't exist at all. So log on to star.com, starassurance.com, or visit any of their offices. You can call them 030-224-0632 and enjoy solid insurance all year round. There is also the Prostacure Tea, which is a specially formulated health drink that improves any problem that you have as far as urination is concerned. Prostacure is from Medimosis Prostate Center. They are at Adenta Barrier, Tema Ajaikojo, or Ahinema Kokobing in Kumasi. You could call them 02081406688 or 0244068444. Well, I'll come back to tell you more about NIIT and the products they have for you as far as your training in internet experience is concerned. Now, my next set of guests, Abdul Malik Kwekubako, editor-in-chief of the New Crusading Guide newspaper. He's a regular panelist, and also Nana Akomia. He is the communications director of the New Patriotic Party. Also in the studio is, I don't know to call him whether the minister or, because it looks like by default he's the minister now. There are pictures circulating all on social media. Maybe sometime we may not get to access social media. Social media where he sounds as if he's the one chairing a cabinet meeting. It is because there are problems with electricity. I'm talking about John Jinapo. Good morning and welcome to the show. The Deputy Minister of Power. Well, gentlemen, if we could just continue on this note and end on that briefly and then continue to the next issues. Let us hear what the Honorable Justice of the Supreme Court, who was part of this panel, Justice Jones Dotse, had to say in the course of this week about the judgment that has been subjected to so much discussion. Let's hear him.
I don't want to interpret the judgment, but as you claim you heard it, the Supreme Court was quite forthright and clear that the use of the NHIS cards is unconstitutional because the criteria for the NHIS card was not based on Ghanaian citizenship, but only on residence in Ghana. So any foreigner who is resident in Ghana for 6 months and more can register under the NHIS cards. That was the basis upon our decision in 2014. And the recent one, we said the use of the NHIS cards is therefore unconstitutional. They should take the opportunity to clean the register of those undesirable persons. Therefore, we also did not want to disenfranchise anybody. So the Supreme Court went on to say anybody who will be affected by that exercise must be given the opportunity to register according to the law and the Constitution. Period. That's it. I don't want to interpret the judgment. If anybody is aggrieved, then they should come back to the court.
Thank you very much. And that was the Honorable Justice Jones Dotse of the Supreme Court, who was also on the panel that decided on the Abu Ramadan and Evans Nimako case number 2. Now, Nana, we've already heard the lawyers for Abu Ramadan and Evans Nimako say this comment is a vindication of the position of the plaintiffs, as in those who went to court. Is that where you stand? That he has said anything that vindicates anything?
Well, thank you, Samson. Let me wish your viewers a good Saturday morning, and my good friends, the Deputy Minister Nkweku Baako, and yourself. Yes, it's a vindication of the plaintiff's case as far as the treatment of the NHIS card holders who got onto the register is concerned. As far as that particular matter is concerned, the treatment for the NHIS card holders is a vindication of the plaintiff's case. You remember, after the Supreme Court judgment, there has been some sort of contest between different parties as to what exactly the Supreme Court ordered regarding the people on the register who came on using NHIS cards. There has been some contest. And indeed, the contest came to a head when the statement came from the Electoral Commission, which purported to say that as far as the Electoral Commission was concerned, the Supreme Court has not ordered the Commission to delete NHIS card holders on the register. So that contest came to a head.
Purported, or that is your interpretation of the statement?
Well, that is my interpretation of the statement.
Okay, because the statement said that those were to be deleted by means established under law.
Well, the crucial point is deletion.
Right.
That's the crucial point.
Okay.
And the Electoral Commission did not state categorically that they have been ordered to delete NHIS card holders. So the plaintiffs were actually preparing to go back to the Supreme Court to seek clarification. And then Justice Dotse's comments have come in, and helpfully, his comments were very categorical on what the Supreme Court has ordered as far as NHIS card holders are concerned. Justice Dotse said categorically that the court has ordered that those names be removed.
Okay.
And
sorry.
that they should
so
be
let me
given a
read
chance
briefly
to
the
come.
Electoral Commission statement so that we are in perspective. The Electoral Commission said, for persons, and I'm quoting the statement, for persons who registered with NHIS cards, such registrations were lawful at the time of registration and the subsequent declaration of unconstitutionality in the earlier Abu Ramadan case does not automatically render them void, quoting the court. Such a position, according to the Supreme Court, would have the effect of disenfranchising the persons affected, quoting again. Then they end by saying this is their own. They say such registrations should only be deleted by means of processes established under the law. Is that what you say the EC didn't give any indication that it had been ordered to delete? Because they say, this is what they say, that the understanding is that they were to delete only by means of processes established under the law.
But Samson, for the Electoral Commission to state that they have to do a deletion by law, that is saying nothing. Because everything that you do must be backed by law. And if the law didn't exist, but you have been ordered, you have to make sure you have the law to back what you have been ordered to do. So really, that's not saying anything.
Okay.
But whatever it is, the plaintiffs, you remember, were going back to court for clarification. And then in that process, you have the statement or the comments from Justice Dotse, which stated categorically that the order is to delete NHIS card holders, in addition to some others. So that there was no ambiguity.
Okay.
There's no ambiguity whatsoever. And then Justice Dotse said, well, if you don't accept what I'm saying to you, you still have the liberty to come formally before the courts. So as far as the NHIS cardholders are concerned, the comments by Justice Dotse vindicates the plaintiffs. It should put an end to the matter. But if some people, some parties are still in doubt as to what the Supreme Court meant on the NHIS holders, they can still come before the court properly, like Dotse suggested. And they'll get a formal response from the Electoral Commission.
So what you're saying is that because of what Justice Dotse has said, the plaintiffs are no more going to the court for any clarification. So whoever is in doubt or is aggrieved, Justice Dotse said whoever is aggrieved, you are saying now that it may be the EC that will have to go to the court to seek clarity.
Well, in terms of seeking clarity, I believe that it is still in the interest of the plaintiffs to go to court, because the statement from the Electoral Commission as to how it will deal with the NHIS code, that statement is not clear. I don't get from the Electoral Commission statement that it is or it has been ordered to delete NHIS card holders. I don't get that from the Electoral Commission statement.
They proceeded by saying that the judgment of the Supreme Court affirms the Commission's consistent position on the status of the current voters register and the mechanism for cleaning it. So they say the court has endorsed what they were already doing and the process to do it. And then they end on the note by saying, they come to this note to say, it must be noted that the EC by itself has no power under any law currently in force to unilaterally delete the names of persons from the register. For persons who are already on the provisional register, the law requires that an objection is made during the exhibition process, either by a registered voter or an official of the commission.
All of these words and sentences that you have read, Samson, there is no clear indication as to what will be done with people on the register, about 900,000 people or so, who came onto the register with NHIS. There's no clear indication.
I thought the number was more than 900,000.
Well,
I thought we're talking about in excess of 4 million or so.
NHIS.
Is that not the case?
The NHIS?
Yes.
4 million? That's the entire register.
Well, in fact, in the court's earlier judgment, it said the majority use that for the process.
Wow.
Well, if it's 4 million, that means the entire register must be replaced.
Okay, I need to be clear.
Yeah, we can
well,
be clear.
maybe I'm mixing some figures, but you can help me out if you are watching all of you. Yes, let's hear you. You have your figures from your constituency. In your constituency, there are how many?
I'll share that with you.
The figure that I have from the NHIS themselves, the special registration that they did in 2012.
That was a special registration, no?
Yes.
That's a special. That's separate from the original registrations.
No, the NHIS, the ones that they did in 2012.
Okay.
It came to about 900,000.
Okay.
So obviously it could be more because they have been back. But if it's 4 million, then in fact we should address ourselves to that number, because that would mean that replacing the entire register. But I'm sure we can all verify the numbers quickly.
Okay.
But
right.
the point is that this statement that you've read from the Electoral Commission does not address the key issue. What should happen to NHIS? One party, the plaintiffs say, and indeed a lot of the mainstream media say, that the Electoral Commission has been ordered to remove the names of people who got onto the register of NHIS. Yes. That has been the point of contention. Not about the processes or whatever.
Yeah.
The point is that have you been ordered to remove NHIS or not? The Electoral Commission statement is not clear.
Right.
So, and you get all kinds of commentary.
Right.
And
okay,
you are speaking to Dr.
Yes.
So, that is the issue at hand.
Yeah.
And the statement from, and indeed that was why that particular issue was put to that Justice Dotse.
Now,
and he's made a categorical answer.
Right.
But
now, John,
I think it's in the interest of the plaintiffs to still go and seek formal clarification.
John, isn't it intriguing, really, that initially the media persons who were in the courts when the judgment was delivered on the 5th reported that the court had ordered for NHIS cadres to be removed. And hell broke loose in high places in this country, including from even officers of the Electoral Commission. They were so unhappy, and they took on some of the journalists in a manner that the journalists have not come forward to say that this is how they were dealt with. Then subsequently we heard Johnson Esedun Ketia and the rest all over the place saying that those who were to be given the opportunity to re-register were minors. Because if you're a minor in 2012, you will not be a minor in 2016. And then some of us came out to point out to them that you cannot give a minor the opportunity again. You cannot give a foreigner opportunity again, because they were all breaching the law, and by the law you cannot benefit from your crime. So we have cleared all of those people out, and now we are setting that it is NHIS card holders. What the Honorable Judge said, from how you understand it, has it shed any light? Has it done anything?
Well, let me thank you, and also greet my seniors here, and quickly state, I think that some people, because they see me more in the media, as you rightly said, they are tempted to think that I'm the minister. I'm not the minister. The minister responsible for that sector is Honorable Setekwe, and it's a normal practice.
Honorable
Setekwe.
He's the minister?
He is the acting minister.
He's acting for power. Okay, right, okay.
It so happened that he was out of the country, and so I had to represent him.
He's got the whole economy to deal with, and he's going to add power.
I can give you instances where ministers of finance
I know.
have acted for both power and petroleum, not just power.
Okay.
I think it's about putting in place effective systems and mechanisms and institutional framework to deal with the challenge. And so far, he's been very, very helpful. One of the key issues has to do with the financing of the power sector. But let me come back to the substantive issue. First of all, I think that all of us want a free, fair, and transparent election. That is the basis. And so delete names, don't delete names, validate, whatever it takes. We are working towards ensuring that we have a very credible election as far as possible. And so that is the basis. Two, I am a bit surprised, and I think that some people share that with me. I've never heard a judge of the standard of a Supreme Court judge make these comments. I've never heard that. That is not to say that Justice Dotse is wrong or not. There could be a novelty. It could be a new order. It could be that he is trying to do something new. And I'm not going to wade into whether he's right or wrong.
Judges have been addressing seminar, fora all over the place.
I'm saying that I've never heard a judge.
And media go there, and if they are the ones who are the facilitators, we speak to them and they speak to the media.
I said I've never heard a judge grant an interview to a journalist.
You've never?
No, I've never heard.
Oh, I've heard many in this country.
On a judgment from a case that he says.
Now you're making a differentiation.
I was building a point.
Right.
Oh, judges make comments. Judges are entitled to. But I'm saying that in this specific instance, where a matter comes before a judge, the judge rules on it, there's controversy, and the judge makes public commentary about it. I've never heard that. But he is entitled to his opinion. I respect him. And so I leave it as such. I do not want to go there. 2, when Justice Dotse was commenting on the matter, he was very emphatic. And this, for me, is what I want to rely on, that I am not interpreting the judgment. He cautioned that he doesn't want to interpret the judgment.
Okay.
So this whole issue of, oh, Justice Dotse has clarified it, he has interpreted it. The only way that we can legally interpret this case is when we go back to court. Not until we go to the Supreme Court. Whatever any other person, in any case, he's not the only person who has given an opinion. We've heard learned lawyers, lawyers who have been in the bar for so many years, give their comments, their understanding of the judgment. And so the fact that Justice Dotse is giving some commentary about it, maybe because he's a Supreme Court judge, it creates a bit of anxiety. But legally speaking, and you're a lawyer, for me, it's of no effect. The only point when we consider, look, there is a proper interpretation and it has a legal effect is when you go to court. So not until you go to court to seek a clarification from the entire membership of that court sitting on the case. I'm clear that Justice Dotse, in his mind, it's quite clear that he wasn't speaking for the court.
When you go to seek clarity, they may just ask one of them to do the clarity.
Let them do that and let that be on record.
Okay.
Until we do that, we cannot make this. And he himself said, look, if you have issues with the judgment, come back to court. And so you can't take just one portion of his statement and create it as if he interpreted the case.
Okay.
You see, the other frustration for me had to do with the way and manner the case itself was reported. And that is why we are wading into whether somebody won it or somebody did not win it. Right after the judgment, it was about who has won the case or who has not won the case. But I'm sure that listening to Dr. Raymond Atuguba, he tried to distinguish the issues. And it's quite clear that the Supreme Court, in my opinion, gave 2 issues. The NHIS itself and the fact that the Supreme Court did not just say go and delete it. And the Supreme Court could have done that. They would have just said go and delete it. But they were cautious in saying that if you are doing so, give them the opportunity. And so if the Electoral Commission says that...
No, in the order that they gave, they said take steps immediately to delete. Yes, when you are done, give them the opportunity.
Give them the opportunity.
So take steps immediately
and
to
so
delete.
If you just go and delete and you don't give them the opportunity, there's a challenge.
Okay.
So 1, there's the issue of whether to delete or not. And 2, there's the issue of giving them the opportunity.
So you agree with Dr. Atuguba that it has to be the case that people must give information about people who registered with NHIS card?
I think that is an issue for the Electoral Commission to determine. I
That's
think that
Electoral
for me,
Commissioner.
the Electoral Commission should determine that. Because they are a constitutional body. It's a creation of the Constitution. And the Supreme Court did say that they did not want to wade into the administrative matters of the Electoral Commission. The Electoral Commission has CI-91, and that should guide us, in my opinion. And so, whether we should adopt this process or that process in dealing with this challenge, I believe that it is vested with the Electoral Commission. On my part, I'm a candidate. And as I told you, we have done our research. We know the number of people.
How many in your constituency?
I would share that with you.
But why is that a secret?
That one is for John Jinapo and his
Why are you treating it as a secret? How many are in your constituency?
And so we have put in place contingency measures, just in case there's the need, because I am certain in my constituency, all those who register with NHIS cards, we have done our checks from our parties and all of them qualify. They are Ghanaians.
Okay, just that it was by mistake
and
that they used the
and
NHIS
through no
card.
fault of theirs. We gazetted a CI, they went through it, they registered their Ghanaians. And so once that opportunity comes, they would register.
Okay. But then something, what it means is that, I mean, the Honorable John Jinakpo has been able to find out the NHIS registration. So what it means that it's possible to quickly find out the NHIS registration.
Yeah, that's why
the EC has not said it has any difficulty with that. Okay,
yes,
thank you.
The EC itself says it has no difficulty. And I'm saying that
but again, John,
we are putting
when
in place measures.
the statement is repeated often, that the court said that it will not want to wade into the administrative affairs of the EC because it's independent and so on. It's not exactly correct. I think people must read the judgment and read every part of it rather than let people quote portions and just end there for them. The court, as we know by the Constitution, has power if people are exercising discretionary power and they exercise it capriciously and reasonably. The court has power to hold you to account. And the court said, if you take a wrong step, they have the power to correct you.
But Samson, okay. just quickly.
No, I didn't say you should comment.
Because I thought that.
Yes, Kweku, yes. What's the relevance of what Justice Dotse said?
Well, I think he settled the issue.
He did?
Relative to the what that the Supreme Court had ordered.
The what?
The what. Even leading from that, we can go into the how.
Okay.
But once it was clear, there had been a controversy as to what the Supreme Court had said relative to those who were holding NHIS cards. Those who use those cards to acquire their registration. There had been some controversy. It's true the EC itself, in its statement, as you're saying, and last week we had to come back to do that clarification, even though I think it's a bit blurred, not very direct, but it's still there that they had acknowledged that those cards were part of the things to be taken out. But earlier on, there have been all sorts of commentaries that pointed to the fact that, people were rather misrepresenting the judgment. Now we are clear, and Justice Dotse was doing the right thing at that time. He was performing an administrative duty. They were in a workshop.
He was teaching other judges on the CI 91 or so.
Yes, and then he's asked the question. And this is of public record. The judgment is in the public domain. It's a public record, a fact established. And he only explained and clarified. He said he wouldn't interpret. I understand that extension. He wasn't going to give you the rationale and all the things that went into it. But he told you the facts, the bare facts. What constituted, that went into the...
He said we ordered the EC to delete.
That's
and to give opportunity to re-register.
Is that not what is in the public record?
It's already in the judgment.
It's in the judgment.
Portions of the judgment and in the order.
And this whole argument, this thing about the code of ethics and things, well, I'm a street-minded guy, but I don't see where he's violated Section 3.9. I don't see it. Even the point about, see, let's put it this way. Let's read the comment.
Right.
The requirement that a judge abstain from public comment regarding a pending proceeding continues during any appellate process and until final disposition. A case is impending for purposes of this section if it seems probable that a case will be filed, if charges are being investigated, or if someone has been arrested although not yet charged. A judge may, consistent with this section, make public statements about a pending or impending case in the course of his or official duties. Quote, in the course of his or official duties includes statements made in the courtroom and on the public record, as well as those statements made by a judge in the performance of his or her administrative duties. Now, the key point here about the journalist sentence, this is my understanding, says the judge may not discuss the rationale for a decision. However, unless the judge is repeating what was already made part of public record, speaking to a journalist is public comment, even if it's agreed that the statements are off record. Comment statements are interchangeable. They mean the same.
Well, the lawyer, Atuguba, says they don't mean the same.
No, but listen to the drift. Listen to the drift. It says, speaking to the judge, it says the judge may not discuss the rationale for a decision. However, unless the judge is repeating what was already made part of the public record, speaking to a journalist is public comment, even where it is agreed that the statements, public comment, even when it is agreed that the statements are off record. Comment and statement here are interchangeable. That's what it is. But that's clearly what it is. You understand?
I disagree with you.
Oh, you are
disagree with
you
him?
are entitled to disagree, but this thing is here. It's not Chinese.
Right.
It's as simple as that.
Right.
You see, let me tell you something. There is this shifting cultivation by some people. This Justice Dotse has created a situation where some people are doing shifting cultivation. Indeed, leading to them dancing panlogo with the issue. They are embarrassed. Those people were the first in the line of those who claimed that the Supreme Court judgment had nothing to do with the category of NHIS card-bearing people.
Right.
They were emphatic and thought that had been conjured from nowhere. Now suddenly you get a member of the panel going on public record to explain what is already known as a public record. And instead of dealing with the issue, all they do is not to raise the ethical issue. Oh, the man has violated the code of conduct. Unfortunately, this document does not help their cause. So they must shift. Ethics, ethics, ethics. It doesn't arise. It's not there. Let's focus. Now that we know. And they said the man didn't speak for the Supreme Court. In what capacity was this? That was part of the shifting cultivation. The judgment itself was a unanimous decision.
Right.
They all had agreed. I heard your introductory remarks. So really, what are we talking about? He didn't go out saying that I've been declared the spokesperson for the Supreme Court, so I've come to tell you what the Supreme Court thinks. Here was an environment, a contest, a training program on CI 91, still election related.
Right.
So, and the journalist goes and says, oh, can you clarify these things? And the man answers it within contest.
You said he spoke about the what, but not the how.
In the sense that he restricted, and I'm sure that's what he meant by
the present controversy not about the how.
No,
rather
see,
than the
there were
the
those. No, some of us had gone beyond the what, but there were others who were not, and there are those who are doing the shifting cultivation. I'm telling you.
Okay, so those actually disagree with the EC.
Yes, and you see, they have a problem. Those who were still bogged down on the what, that matter has been settled by Dotse's clarification. And instead of them being courageous to accept that, oh, so we erred or we misunderstood, they are now checkmating the man on ethics. Very useless venture.
No, but is that also not a concern? Because like they say, you hardly have these things happening. I am a fan of the US Supreme Court, and I've followed how Justice Scalia and the rest could get into debates. I mean, very active debates after they have given a judgment. But that is US, that is not Ghana. Is this not rather, something new?
This code of conduct, was it made for US justices?
No, it was
this
made
code
for
of
Ghanaian judges.
Yes, so we are still within realm.
And it's made based on international standard practice.
Yes. So what are we talking about? We are within a Ghanaian jurisdiction. This code of conduct guides the conduct of judges and magistrates. And I can tell you, even though I'm not a lawyer, you are, Section 3.9 has not been violated by Justice Dotse's comments or statements, whichever way you want to put it. But I'm saying that you see the how is the way forward.
But you see, your definition and interpretation may not sit well with a legal mind, because you say public comment is synonymous with
public statements.
Public statements.
Yes.
A lawyer may tell you that public comment is a legal term, and it has a different connotation from this.
Yes.
And as far as they are concerned, what that means is that, like Dr. Tiguba says, what that means is that you don't make a statement to a journalist.
I am saying,
You're done. Let's move on.
It's basic English.
Okay.
Even though I'm not very well educated, I can read and understand this basic English here.
Yes. So you said he settled the what, not the how.
Because he didn't have to. I'm sure that's where he was restrained. And that's where he said that you can come back to us, where we will deal with both the what and the how, so that you people will have better clarity. I suspect that's
both what and how. Both what and how.
This is my analysis now. I'm not saying that's what he said. But you see, let's not ignore the fact that there is still the issue of the how, because of things that the EC and others have said. The attempt to suggest that, look, we can use CI 91 to do it, meaning the exhibition, the provisional display of the provisional register that leads to the
challenge.
I think it is not the cure for the mischief. If you read the CI 91 carefully, it's not. And you see the order that says immediately. Who was the order directed at?
Directed at the EC.
Who has the database for those who
have?
The EC. And the exhibition. I go to the exhibition place. How would I know my brother John used the card?
Because you don't have the data.
Thank you. So first and foremost, the burden of actually identifying those who use the card, and for that matter, removing them, lies on the EC.
Dr. Tuba explained that there's a two system. The system is twofold. Either the public doing it or the EC officers doing it. The EC officers.
The public one is a non-issue.
No,
it doesn't arise.
Okay.
It doesn't because, you see, maybe I will know one or two people who use the NHI because perhaps they are close to me or they've told me.
Okay.
We are talking here the scale, and we are talking of the original repository of the information, and that is the institution called EC.
Who was asked in court and who confirmed?
Well, that part, in reading the Benny thing, I have a little difficulty with that, even though I think, in fact, they must have. But you see, if you read the concurring judgment, and there's a place that confuses me, and I was going to raise it all the same, page 37.
Okay.
Justice Benny's, the concurring judgment.
Right.
He says the defendant's serial, and the defendants here is the EC, isn't it?
Yes, the EC and the Attorney General.
AG. The defendant seriously challenged this on ground that the first defendant cannot be compelled to act in a particular manner. They claim they will not be able to identify those who use the NHI card to register.
Right.
Who is that in reference to?
The EC.
Yes. So I was wondering what happened at the court. You know, we need to get the court of the proceedings to see how it went. But this is a concurring judgment. And the judge made that point. And so that more or less challenged my earlier knowledge or information to the effect that they had said they could identify. Here, it's not showing. But you see, all the same, Justice Bennett made a certain interesting point. And that's why I said the how still has to be dealt with. You realize he commented on CI 91.
Kweku, but what you spoke about, the inability to identify, does it make any difference in page 21 when they said that it appears from the proceedings herein that the exact numbers are not known? This creates some difficulty in determining the actual percentage in order to answer the question posed whether the register may, on such ground, be said to be reasonably accurate or credible. However, that should not present us with an insurmountable problem. And then they went ahead to solve the problem.
Yes.
And they said delete them.
Yes. So here, it doesn't change the point I made. We're talking here identification. The defendants having told the court that they would not be able to identify. I'm quoting.
Okay.
I'm not justifying.
Right.
Because I don't think they have any basis to say they cannot identify. I don't think so. If you are going to register, you go with some primary document to be able to get onto the thing. And I expect the EC to keep records.
From 1A,
I'm told from 1A. And I'm surprised if that is also not captured in the form of technology, that is software, in terms of their database. I'll be surprised. It shouldn't just be the physical paper, the paper that you put there, which can get bent anyway or can get stolen.
Okay.
I believe they must have this, but that's something that my competence is not exactly at par with. Okay. So I wouldn't want to run into an area I cannot thoroughly interrogate. But you see, I also discovered something. And again, this may be an uneducated...
You have rewritten the judgment.
Yeah, I'm doing, that's what I do to all my...
copy.
Yeah. See, I may be, this is an uneducated observation.
Okay.
But reading page 44, that is a concurring judgment. Justice Bennett said, I will take this opportunity to comment briefly on CI 91. In view of all the happenings in respect of the eligibility criteria of potential voters on the register, one would have thought that any change in the law would have made provision for the form of identification used by a registered voter to be captured in the first defendant's database. This would have made it easier in future for the court to make definitive pronouncements on the status of persons whose names appear in the voters' register. It is sad to recall that CI 91 has been published without this important information. It is good to draw lessons from court decisions in order to inform future conduct of state actors. Regulation 22 of CI 91, and this is critical, did not improve on CI 71. 72, sorry. If this court's decisions do not guide the future conduct of state authors, then problems of needless litigation will never be stopped and the country will be poorer for it. An offshoot of court decisions is to provoke and influence change or reform in the law to prevent or reduce future litigation and conflict. My point is this: CI 91, in spite of its inadequacy as described here, at least led to the repeal of CI 72 because the pronouncement, the affirmation that the NHIS were unconstitutional.
Right.
That was in line with the court thing, even though it didn't improve on it.
Right.
What is the drift? See, CI 91 today, if you look at the exhibition procedures, clearly will be inadequate and ineffective if you want to use that to deal with the NHI thing as we've just established. So take a cue from here. If the Supreme Court order, which I think is a straightforward order, Article 2.2, they said some declaratory reliefs as distinct from what? Substantive reliefs. I don't understand that. This is coming under Article 2.2. It's what? Enforcement of the Constitution. 2.2, if you fail to deal with it, you go to where you'll be committing high crime, isn't it?
Yes.
Assuming with all my ignorance that this does not amount to law, take a cue from here and go put in place the relevant, appropriate, applicable legislation, in this case, a constitutional instrument. Improve on 91. The cue is here. Take a cue from the last judgment and improve on this section, especially the exhibition place. Give yourself, empower the EC, if there's no such empowerment, to actually, under the cover of the Supreme Court ruling, to delete. Look, and how do you delete? You can publish the whole people who use NHIS. And that's notice to them that they are going to be deleted. So ought to come for the opportunity to re-register. Who says that's a mission impossible?
Okay.
It's not a mission impossible.
All right.
The minister has done it.
All right. Okay. Thank you.
I think that it's still clear that, look, despite what Justice Dotse has said, if you want clarity, just as he said, go to court and seek clarity on the what and the how.
Kuku said the what is not in controversy.
He himself,
because if you say the what is in controversy, then it means you are in disagreement with the EC. And that's the problem Kuku has. And I think I have it equally.
In disagreement with
because
the EC.
the EC says it understands that it is supposed to delete NHIS card.
I'm saying that if anybody has issues, he should go to court on the what and the how. Two, I'm saying that Justice
anybody at all cannot get up and go to court.
No, I'm saying
either
that.
Either the EC or
the parties.
The parties. The EC says, I understand I'm supposed to delete NHI people, but I'm supposed to do it under the existing law.
Yes.
The plaintiffs disagree.
That's
they say the order of the court is law. Go ahead, delete them, offer them the opportunity to come and re-register.
The EC says that it has the mechanism under the law to proceed, and that in their mind, what the court has said affirms their position. And I'm saying
the mechanism that in 2014 the court said is a mediocre process.
Look, there's a CI.
And rejected it.
There's a CI. We have CI 91. The EC says that it has the mechanism to move forward. And it believes that what the court says sits with it.
All right, so
if the parties have a problem, let them go.
They didn't. CI 91 lacks the efficacy to deal with
this is just saying so. This is Justice Benning saying so. That they didn't improve on it.
But
yes.
One second. I'm interested to know how the minister was able to isolate the NHIS card.
It's very easy. We have
very
a
simple.
full database of our NDC
They let
members.
my vote count people.
They
say they have actually gone to some of the offices.
I'm saying that.
So you went to the EC office?
No, I'm saying that we, in my constituency, the NDC office, we have a full database of all our members.
Yes, but your members are not necessarily elected.
I'm saying that we have a database of our members.
Yes.
We know those who registered with this, registered with that.
Then the issue
and we are putting in place measures
It's not
to
difficult
help our people,
Yeah.
not the entire constituency, members of the NDC.
Okay, so
And
an
if the
aspiring
NDP wants
member
to
of
do
parliament
this,
is
that's
able
their
to
own
do
issue.
that.
Then
The Let My
very
Vote
easy
Count
for-
Alliance is also able to go to EC offices and procure the forms and identify persons.
Let me reiterate this so that
it's a very easy matter.
So that nobody misquotes me.
Dr. Rekurobe has spoken about the enormity of the work. If they have to do it, then there will not be time.
Who said there will not be time?
I am saying
more than enough time.
And let me put it on record that in my constituency, in the NDC office, we know our members. We know who registered with what and who registered with that.
That you have said.
So if it becomes a problem, we would deal with it at our level as a constituency.
Okay. Maybe on your own initiative, get those people to go, submit themselves and re-register. Well, so that they don't get into any trouble.
That's a good one.
Anyway.
So let the exhibition come
thank you,
and let us go and do that.
Thank you very much. And this one from Nana Santibede. So he says that at page 9 of the judgment, the court sets out the purpose of the plaintiff's claim as follows. Quote, in our view, and I have checked it, in our view, looked at from this standpoint, the plaintiff's claim seeks to give teeth and meaning to Articles 42 and 45A of the Constitution by ensuring that names of ineligible persons, minors, and descendants, that is dead persons, are deleted from the register before the upcoming public elections, unquote. It seems to me that the 3 reliefs granted and the consequential orders made clearly favor the plaintiffs, so I am at a loss as to what Dr. Tuguba means by when he says the plaintiffs lost. As for this other analysis, saying we'll take a quick break. We'll be right back and to think about social media shut up on the eve of elections. How will it be like? We'll be right back.